Welcome back to another episode of Life in the West Suburbs, where we talk about all things life in the western suburbs of Chicago, from real estate to property tours, to talking with business owners and talking with people just about owning real estate in general. And today, joining me is David Butto with Krieg Devault. David, thanks for joining me today.
Of course, anytime. It's a pleasure.
Yeah. So tell me about yourself and your practice as an attorney.
Yeah, so I've been a lawyer for 30 years. I do litigation, a lot of fraud claims, primarily a lot in the commercial lending, commercial area, but a lot of residential stuff too. Primarily what we see in that vein and what we were brought in here to talk about today are things under the Residential Real Property Disclosure Act, how those intersect with fraud claims, kind of what the idea of fraudulent concealment is, how those interplay with what things should have been disclosed when you're buying a place, and what you can do about it if you feel like you got taken advantage of.
Yeah, absolutely. So let's start there. So every house that sells, I shouldn't say every house, pretty much every house that sells in Illinois, the seller and the owner have to fill out the residential real property disclosure report, which is,
Yeah.
I think it's 24 questions now, right? The added question
23.
of it's 23. Okay.
Yeah.
Okay. I know they just changed it. The added question of, has the property been ever used to make methamphetamine, kind of always throws a lot of
Right?
people off.
Big,
Uh,
big, big focus.
yeah. So it's 23 questions and you got to answer, take through how they have to answer
Sure.
just as truthfully as possible, correct?
No problem. So it's going to apply to a single family home, to anything up to a condo up to 4 units. It doesn't apply to new construction. The owner is going to have to complete it. The definition of owner can be a little wonky, depending upon if it's a trust or who's a beneficiary. Effectively, what you want is someone who's lived there, to be making the disclosure. There's a common misconception in completing it that, gee, if I bought a place that then has some defects, I automatically have an action under the act. That's actually incorrect. The person completing the disclosure can have a reasonable belief that they have remedied whatever the defect is, and then not disclose it. So it's not that it didn't exist. It can be that I thought I fixed it, and therefore I didn't violate the act. Obviously, that's going to present a lot of fact questions, because the number one time we see this is, oh boy, it just rained like it has this week. You're rolling your carpet out to the curb and you have a completed disclosure that says the house never flooded. You're talking to the guy across the street who's retired and says, oh, these houses have always flooded. Then we have a problem. So, there's a huge intersection between a lot of fact issues on what was disclosed, good faith belief, etc. Importantly, what you want to keep in mind is that under the Real Property Disclosure Act, you have a year to sue. And unlike a lot of other statutes of limitation, the discovery rule doesn't blanket apply to that. That is to say that I don't get to toll the time to sue by the time that I didn't discover or reasonably should have discovered the defect. So if you've gone through a dry spell, you have a couple seepage incidents, and you're going beyond a year, you're most likely going to have blown your opportunity to sue under the act. Now, Illinois courts have kind of placated themselves in ruling that way by saying, look, you have all these other actions under fraud, fraudulent concealment, warranty under the contract, and there are a bunch of other tools at our disposal that we can use if you have blown that time. But you want to keep that front and center, because the Residential Real Property Disclosure Act allows attorney's fees, and that's a huge threat in any piece of litigation.
Now, so you obviously have to disclose something if it's a known issue, and you mentioned if you think you reasonably fixed it, right, then it's not
Yep.
necessarily a disclosure. Is there any duty for the seller to have to, like, okay, do I have asbestos? I have to go search and test for asbestos, or
Yeah.
to
That's
actually
that's
make an effort to discover issues?
Yeah, that's a great question, Ryan, and I would answer it in two ways. Under the act, no, not necessarily, and that's what it's designed to eliminate, because in a fraud claim, I have to have a reasonable reliance on the misstatement or the concealment, which is to say that in a fraud claim, I may have an obligation to go and have inspected something. Not applicable here, but a lot of time in commercial buildings, we'll see asbestos that has been thrown into an abandoned elevator shaft or some sort of remediation. In the residential context, you're really looking at older homes, whether there's lead or other disclosures or an asbestos thing or seepage like we discussed. So you don't necessarily have that obligation. And depending upon the seller, we can maybe throw some consumer fraud things into it as well, where that obligation would be eliminated. But what you really want to do is ask those questions because those are going to go in kind of the fact issues if you're litigating against a seller of whether you should or shouldn't have told me it. So there's a big difference between not asking it and having someone tell you that it was not disclosed because they thought we fixed it, and then asking it and then having a seller affirmatively represent to you that, yeah, we had the house mud jacked and then waterproofed, and we thought that that fixed the problem. So you really want to put those markers in the sand for someone like me to be able to pluck really nice, doable exhibits in a demand letter if you feel like you got taken advantage of out of the gate.
Now, we touched briefly on it, but why did they add? Because that was a recent ad of like the property has been used for the manufacturing of methamphetamine. Like, what's the backstory of adding that, and why consumers should look out for it?
Sure, your guess is as good as mine as to why that became a specific issue, but we're looking for chemical residues, things that are left behind, really environmental. It's a darling issue. I don't think there's any magic to it. I think it's just kind of a general statement.
Okay. Fair enough. Now we do mostly talk residential, but commercial real estate is a big part of the western suburbs of Chicago. So if people are considering, you know, investing into some commercial real estate or purchasing into some commercial real estate, what are some things they should look out for? Because there's not the property disclosures like there
Right.
are in the residential side, and it's
Yeah.
it's operated a little bit differently. So what are some
Right.
cautionary things buyers should consider when getting in that space?
Sure. So if you're going to invest in a commercial property that's a unit that's inside of an association, you're still going to have the disclosure requirements of the association under 22.1 of the Condominium Property Act. So what you want to do is make sure your attorney is looking at all of those disclosures, particularly disclosures of any assessments, ongoing litigation, so that they can do due diligence to see what those things are about. You're also going to need a really Loctite inspector. And ideally, what you would have is the inspector forward that inspection report to your attorney, or the law firm that's doing the closing, to just indicate whether diligence items need to be checked out. They could be, easements, structural issues, chemical, environmental, asbestos. The other thing you want to be really, really looking out for in a commercial investment, particularly in rehab buildings, in the burbs and in Chicago, those buildings are very, very old. They're going to require a lot of tuck pointing, a lot of maintenance, particularly those that are situated between rail yards because they're getting shaken all of the time. So you want someone out there that's going to be able to structurally look at these things, create a report that maybe both people can sign off on, and link that with the 22.1 disclosures so you know that there's not a problem, at least as best you can.
And how do the inspections from residential versus commercial, like how would those vary? Maybe I'm an investor that I've done a lot of multifamily and I'm used to having my inspector check the furnace and the AC and all that. How would that differ then on, say, a commercial building, or what they're looking out for?
I think commercial is going to be a lot more thorough. There's going to be a series of firms that are really known for it. They're going to know exactly what they're looking for, from looking up the age of any roof repair permits that were pulled, any OSHA violations, looking at where the elevator permits are, when there were rehab records with the city, as well as being able to look at things on title like easements people might not have discovered or disclosed. We've had a few where there literally have been railroad easements that led us to some environmental discoveries on some commercial things. So it's just going to be a lot more sophisticated, particularly on the investor side, because on the investor side, you're going to be deemed to be taking the risk. Particularly if you're inside of a single purpose entity that you're investing in, the operating agreement that you're going to be inside of on a commercial venture is going to have those warnings in it. If it's a PPM or something else, you're going to have warnings in it. So you're going to want something distributed to all the members that you can be pretty confident in. On the residential side, you're going to want someone that's thorough, but maybe not as thorough as you're looking on the commercial side. Someone who's going to go through the checklist of the disclosures, look at the roof, look at the siding, look at the basement, look at the foundation, see if there are any waterproofing issues. Maybe take a couple of trips out there. Also look at the records that are on file with the city. Were there permits disclosed? Was there a basement that was furnished that wasn't permitted? That's going to be discovered later on. And then your assessed value of the house is going to magically go up and your tax bill is going to go up $1,000 the following year. And you're going to be like, honey, why is the tax bill $1,000 more? All those are the things that you want to, kind of eliminate as surprises. On the commercial side, it's just a lot more sophisticated. On the residential side, it's less sophisticated, but there's still a lot to button up. And you're seeing a lot of communities now, out here that might be, were built in 2000, 02, 03. They're right at that time when the useful life of a lot of those elements is going to be gone or well past. So if they haven't been replaced, you want to have those things inspected and understand exactly where things are. You want to make sure the roof doesn't leak. You want to make sure the siding is intact. You want to make sure the basement's intact. Yeah, I think that would be about it.
And closing out on the residential side of things, a couple other disclosures that are needed. There's the radon disclosure, and then there's the lead-based paint disclosure. If I'm not mistaken, lead-based paint, that's like the only one that's needed nationally, correct?
Correct. That is correct.
Okay. And very similar, like you kind of disclose, what you know about it. I'm curious if you would know or have, any history of, there used to be a mold disclosure in Illinois, and then they removed that out. So does that mean people don't have to disclose mold, or what should people know about mold when going into, a residential purchase?
That's an awesome question. You're correct. There is no specific disclosure about it, but I think you could argue that if the house was infested with mold and a seller knew that can meet the elements of a fraudulent concealment. You could even argue that might even be a negligence claim, or even so far as a battery. Those things are going to be obtained from records in the house. You would even go as far to have your own inspection, probably post-purchase, I would imagine, where you're opening up a wall and you have a mold inspector going in and getting counts of the house indicating that has been a problem for years. It happens a lot. You would do the remediation because you have an obligation to mitigate your damages, and then you probably kick off to the races with something to the seller demanding some information about the mold problem. And if they throw up their hands and say, oh, what mold problem? Then you hire someone like us to take it next level and maybe start doing some discovery into what exactly they did in the house to remediate, or if they knew about it. They may very well have pulled permits to do some remediation of their own. They may have records of payment of any remediation services that have been out there. If there's an internal flood or a water incident, if a faucet was left on or there's a water loss inside of the house, there's going to be records of that inside of insurance claims. All those things are things we can touch with subpoenas or discovery to get our hands on them. So depending upon the problem and the value of the damage, it's definitely something you could do. It's just not as easy of a trip lever as something that you're going to hit under the Disclosure Act.
And you mentioned opening up walls. So let's say there's an instance where, house was purchased and then all of a sudden buyer opens up the wall and it's mold that just had never been seen before. I guess this kind of is back to my first question. Is there anything the seller should have done to find it? Or is that just kind of like an unfortunate type circumstance?
That's going to be a fact question, completely depending on the circumstances. And honestly, if it's something that an inspector should have done, you might have a right of action against them. If it's something that was knowingly not disclosed by the seller, it's in their court. But if something is not there and then all of a sudden it's a problem and you're the one that's first discovering it, I doubt that you have an action against the seller if they didn't do something to intentionally conceal it and then pass the house along to you, or if they just didn't know about it. Now, with that said, if there's any sort of specific warranties or something for work that touches those areas, or something that we can touch on the contract, like an addendum to it, then we have some work to do to see what that looks like.
Very good. I appreciate all your time and insight. Anything else people should know about the property disclosure, or their rights if issues are found within that 1 year and they feel there's some fraud coming about?
Yeah, I would definitely just recommend that you reach out to somebody that knows the statute, that can give you the ins and outs of it. Because what you want to do is start tolling that attorney fee lever, because a lot of times these defects are going to be enough to repair to be a meaningful number, but maybe not enough where you think it's going to be good to go ahead and engage someone and file a lawsuit. So you really, really want to be under that 1 year tag to allow your attorney to have all of the tools at their disposal, get that attorney fee lever going, and make their action as powerful as it can be.
And at the end of the day, if you're a seller, don't lie and disclose the information so it doesn't come back to bite you.
It's pretty easy. It's everything we need to know. We all learned in kindergarten, right? Just tell the truth. And if you think you fixed it and you adequately remedied it, just disclose that. Tell someone what you did. Be open about it. Trust me, it's a lot less money to do that and even come to an agreement inside of the contract on what you did to repair and have someone sign off on it than it's going to be to retain an attorney to defend you. So honesty is the best policy. Don't think you're going to pull something over on someone. It never works, ever works. So and you don't get to feel okay about the transaction. If you lived in a home for a while, you're obviously selling your biggest asset. Maybe you're moving on, you're retiring. Do it with a clear conscience. Do it in compliance with the law, and everything's gonna be just fine. And you never need to talk to anyone like me.
Well, I enjoyed the conversation, and I appreciate you taking the time with me and chatting with us today. So, David,
Anytime, Ryan. It's always a
yeah,
pleasure.
awesome. You have a good one, and we'll put your contact information below in case anyone does need to reach out. And I appreciate you joining us today.
All right, Ryan. Really appreciate it. We'll talk to you soon.